We thank you so much for watching Law School Made Easy at Law School Made Easy 256. I want to thank you for the subscription, for the liking, for the sharing of these videos, and we urge you to share, like, and subscribe to our videos. My name is Walter, and today we want to look at the lawmaking process. We want to know the laws we follow that we abide by today. How do we arrive at them? What is that process, that procedure that leads us to those? And particularly, we are going to look at the lawmaking process in Parliament. What happens in Parliament? Of course, there are ordinances, there are bylaws, but we want to concentrate on the Parliament. So let us straight enter the lawmaking process. If you look at the grand norm, the mother constitution, our 1995 constitution, article 79(1, provides for, gives parliament a role of making laws. So in 79(1, parliament has been given the role to make laws. It is strictly the role of parliament to make the laws, not anyone else. However, in article 79(2, Parliament has the mandate to delegate its powers to any other entity as it may need, that we give these to make these other laws, which you call subsidiary legislation. But the primary legislation, the making of laws in Article 79(1, is mandated to Parliament. There is no law that will be made, and it is not Parliament. So any other person or body that makes any other law, it gets that mandate from Parliament, and that is still stipulated in the Constitution, Article 79(2). And when that body is delegated to the mandate to make the laws, that body cannot delegate further. The mandate of Parliament delegating to that body, it stops with that body, and that is where we get the principle of delegare non post delegatus. The principle that you cannot, a delegate cannot delegate further. So let us now go to the process of making the laws. Now, the first step, we have the pre-legislation process, that before the laws go to Parliament, there is a process they pass through before they enter Parliament. That the making of the laws, we know it is in Parliament, but before we go to Parliament, there is a whole process which we call the pre-legislation process. That is the process before we enter Parliament. What are the things done before the bill is taken to Parliament? Now, in the pre-legislation process, one thing you must note is that we have two types of bill. We have the private members bill and the government bill. So in particular today, let's look at the government bill. The process of the government bill, it doesn't differ a lot from the one of private. Now, if it is a government private bill, the first thing we have is the identification of the areas that we need to legislate on. So the agency or the ministry or the government minister will now identify areas that we need legislation. That where do we need to put a law is the first thing they do. That you identify areas where we need to put the law. After you have identified those areas, these areas are now put on two papers. If it is a new law that you intend to bring, it has not been in existence, we now write it on the white paper. But if it is a policy document that we want to improve on the already existing policies, we now write that policy on the green paper. So the first step is to have the white and green paper to identify what we want to bring. If we want to bring a new law, and then we put it on the white paper. If you want to bring an old policy to improve on the policies that we already have, so we shall put them straight on the green paper. Now, after we have done that, now the minister in charge will handle this through a memorandum, a cabinet memorandum, and takes it to the cabinet. Now we have a law, we have identified the area I want to improve. Now the minister gets this and takes it to the cabinet. Now, why is it going to the cabinet? Now, in cabinet, the minister will present. Remember, cabinet is chaired by the president, and now they identify the needs of that law. Is this law necessary? Do we need it? If they need it, they now attach value to it. Which type of value do they attach to it? Number one, they attach value. They invite the minister or the ministry to now tell us, where will you get the money to finance this law? You are bringing it, but we must finance it. Let us give an example. Do you remember the time when districts were introduced? You don't just introduce districts. When they were introduced, the government has to know that when we are adding more districts, do we have enough money to finance these districts? So that is some of the decisions in in cabinet. Now, in cabinet, two things happen. There is approval or not approved. Now, if they don't approve, then the lawmaking process stops there. But for our purposes, they will approve because they are learning purposes. They now approve and say, money shall be gotten. Let us move forward with this law. Now, cabinet will pass the law. Now, after cabinet passing it, that yes, it can now continue with the whole process. The law now, the bill is now taken to the ministry or through the line minister. Now, while there, they are supposed to publish it and put it in a gazette. That is Rules of Procedure, section 117. That this law, after being passed at Parliament, they must at all cost publish it in the Gazette. And the work of publishing the law in the Gazette is strictly given to the Uganda Print and Publishing Corporation, UPPC. That is the one that is supposed to print those copies. And this law should be printed. Now, on printing them, they now attach as a rule of procedure in section 118, they attach the financial implication, that attach the finances. Where are you getting the monies to finance this bill? What would be your source? Attach all those things. That is rule 118. Now, after you have contacted UPPC to print for you, and then you print in the Gazette, you attach a certificate of financial implication, rule 118. Now, after doing that, you now transfer the line ministry and the minister. The UPPC published copies of members of parliament, more than 500 copies. Now, when you publish them in rule 120 of the rules of procedure, you are mandated to send them to the clerk for distribution to the members of parliament. Now, the published copies of the bill are now taken to the clerk of parliament under rule 120 of the rules of procedure of parliament. Now, when the clerk gets these 200 copies, but remember, before you even move any further, remember that UPPC must be issued with an LOP, local purchase order, meaning that it must be paid for the money of publishing by the ministry. Now, when all that is done, it is now transferred under rule 120 of the rules of procedure, transferred to the clerk of parliament. Now, the clerk of parliament will now distribute these copies to each member of parliament. Now, Under Rule 128, the bill comes to Parliament for the first reading. That is 128. The bill is appearing for the first reading in Parliament. Now, this reading is what we call the formality. It is for formality. There is nothing much that happens in the first reading other than the speaker calling the minister to read the title of the bill. And when they read and lay on table, then the clerk of parliament is asked to read the short titles on the bill. And after that, section 129 of the rules of procedure is now evoked, is now put to play. What is section 129? Section 129, a bill is now referred to the committee. Now, to the committee of parliament, this is where the donkey work is done. This is where much of the work about legislation, about bringing a law is done. That in the committee under Article 90, yes, under Article 90 of the Constitution, these committees are made, they have the right to invite anybody of public, anyone they feel is of interest to any matter before them. So they invite people, they invite the ministry, they invite everybody, they consult stakeholders about this law in the committee. Now, this is where the work is done. Committee is created under Article 90 of the Constitution. Now, in Rule 129 is saying refer the bill to the committee so that the committee can work about the nitty-gritties, all the other elements which were not seen. That where are you getting the money? How will you finance this? How is this going to be? Why do you call for this law? Is it necessary? If necessary, tell us from here what you're going to do. All those areas happen in the committee. Now, when the committee has done all that work, it now brings back the bill to Parliament for what we call the second reading under section 130 of the rules of procedure. Now, in the second reading at Parliament, in Parliament, now Parliament is sitting. This is where now we get the input of MPs. That at this point now, the MPs are going to deliberate in the second reading to give us their opinion. Remember, we said laws are made by members of parliament. Now, the second reading, they are performing their obligation, their duty, their legal duty of now making the law. They add in. Now, if they fail to agree, if they bring new so very many amendments, now that one means that the bill will be now sent, again recommitted to the committee to panel beat the areas which the members of parliament have talked about. Now, after that, the bill will now come back to parliament under section 137 for the third reading. And in the third reading still is also formality. There is nothing much which is done in the third reading other than passing the bill. So the bill on the third reading, which is section 137 of the rules of procedure, is now brought to parliament, and members of parliament will deliberate shortly on this bill, and then it will be passed. Now, when a bill is passed, it has not become law. It is not yet law. It has only been passed. Now Parliament has approved that this bill can now become a law. It can work. We can move with it now. When Parliament does that, it now evokes Article 91 of the Constitution, that it is now sent to the President for assent. That Article 91, that the Parliament now, through the Speaker, will send this bill which has been passed by Parliament to the President for assent to become law. Any bill, before it becomes law, the President must append his signature, must approve it and accept it. Now, under Article 91(2), the President will go through this. When finds there are gaps that need to be corrected, the President will send it back to the Speaker this bill. Now, the Speaker under Article 91, 3 and 4 will implement, will look at the areas where the President has advised, and now they would improve it in Parliament. After doing that, the President is given 30 days to assent to the bill. If 30 days elapse, the President has not assented to the bill, then it will be brought back to the Speaker, and Parliament will sit with the quorum of 3/3 of members of Parliament. When they sit, they will pass it, and it will now become law. We now have a law. And when it becomes a law, Article Section 117, will come now to play. Then the law will be put in the Gazette. The bill will be put in the Gazette to officially become a law. So that is how we arrive at these laws. The moment the President fails to assent in the 30 days given, Parliament, with the quorum of 3/3 of members of Parliament, will sit, and the bill will now be passed by Parliament to become a law. And the final step in 91(8), if I'm not mistaken, now the bill will be put in the Gazette to more confirmation that this bill has now been passed and it has become a law. So that is the process of the law making process of Parliament. So we want to thank you for subscribing, sharing, and liking our videos. Keep sharing, keep subscribing, keep liking our videos. Thank you so much. Until next time.